Good afternoon, everybody. We'll just wait a couple of minutes to allow the attendees to get into the room, and then we will get things started. In the meantime, I'm going to go ahead and share my screen. I believe with apologies for the brief technological delay, I believe we are now all prepared to go. Good afternoon, everybody, or good morning or good evening from wherever you may be joining us. My name is Michael Berger, and I'm the Executive Director at the Sabin Center for Climate Change Law at Columbia Law School. Please actually forgive me for one moment while I make a brief technical adjustment. My apologies. Let's try starting this again. So please, everybody, welcome to our afternoon webinar. I will be giving some brief introductory remarks before turning things over to my colleague, Maria Antonia Tigre, to get the conversation started. As the international community prepares for the upcoming Conference of the Parties in Glasgow, it is evident that we are not on track to meet the targets of the Paris Agreement, whether conceived as the 2-degree target or the far more protective and far more necessary 1.5 target. This emissions gap, which may also be thought of as a policy gap, has, I apologize, forgive me for one moment while I adjust a couple of things here. This emissions gap, the gap between emissions that human beings are putting into the atmosphere and the necessary emissions that need to be, the necessary emissions reductions to meet those Paris targets, can also be thought of as a policy gap. And while a great deal of effort will be put into the UNFCCC negotiations to close that policy gap, even as a great deal of effort is being put into negotiations in Washington, D.C. at this moment as we speak, to close the emissions gap here in the United States, an increasing number of stakeholders are taking to courtrooms in order to force action. At the Sabin Center for Climate Change Law, we track developments in these areas, in this area of climate change litigation, maintaining a database of cases filed within the United States and another for those filed in countries and international fora worldwide. The cases included in this database are cases where climate change is a material issue of law or fact. The database does not include all cases that implicate climate change issues or that may have an effect on climate change mitigation or adaptation outcomes. To date, we have accumulated more than 2,600 cases worldwide. Nearly 85% of these cases have been filed in the United States. Other major jurisdictions for climate litigation include Australia, the European Union, and the United Kingdom. In recent years, we have also seen an uptick in the overall number of cases filed, both in the United States and elsewhere. We have also seen an increasing number of cases filed in an increasing number of jurisdictions, including more and more cases being filed in the Global South. Last year, the United Nations Environment Program, together with the Sabin Center, issued an update to an earlier survey of global climate change litigation, which was reflected in this report. In the report, we identify several key trends in climate change litigation, noting the types of cases popping up with increasing regularity. These include cases related to climate rights, cases related to domestic enforcement of climate change commitments, cases related to limiting the production, extraction, and transportation of fossil fuels, cases related to corporate accountability, cases related to adaptation and the failure to adapt, and cases related to climate risk assessment and disclosure and corporate greenwashing. These categories obviously overlap in multiple ways, and in some ways that I think we will all see becoming evident in the presentations and discussion to follow today. And with that, I will turn things over to my colleague, Maria Antonia Tigre, who will introduce our speakers and moderate the discussion that follows. Maria recently joined the Sabin Center as our first Global Climate Change Litigation Fellow. Maria comes to us having spent a number of years working at the Cyrus Vance Center for International Justice at the New York City Bar Association, and with an extensive academic background in the area of environmental law and climate change law. She is also involved with various activities around the world, including a good number of activities related to human rights and climate change. And with that, I'll turn it over to you, Maria Antonia.
Thank you so much, Mike. Thank you everyone for joining us. It's really a pleasure to welcome you to this webinar. We are very honored to have with us Chief Justice Bruno Lasserre, who's the head of the French Conseil d'Etat, the State Council. After decades working at the Conseil d'Etat through different roles, he was appointed as Vice President, which is the highest position at the Conseil d'Etat in 2018. And we also have with us Justice Stéphane Hoynck, who has been a member of the French Council for 16 years. For the last 3 years, he has been Advocate General in the litigation chamber in charge of environmental law. And his role is to give his independent opinion on cases such as the Grande Synthe cases. So without further ado, I'll head over, ask them to start with their remarks. And if you have any questions that you would like them to answer, you can just type them in the Q&A and we'll come back to those later on. So please, Chief Justice, if you can start.
Thank you very much indeed, Michael Berger, for your great introduction. And I learned a lot about what you said about the fantastic databases you built on climate litigation. That will be very useful for us. And thank you very much, Maria Antonia Tigre, for accepting to moderate this promising webinar. I'd like to start by telling you how happy I am to that the Conseil d'Etat and the Sabin Center for Climate Change teamed up to organize this event. Here in France, we only care about those partnerships that allow us to share on issues that matter on both sides of the Atlantic. This being said, I'll introduce the two decisions we recently issued here in Paris by asking three questions. And the first of them being, why judges? Why climate change issues begin to come before judges? I'd say that even though climate concerns were not born yesterday, we seem to have recently reached a turning point. For the facts speak for themselves, and the idea has emerged that it is no longer possible to wait, as we are facing a climate emergency that no people in good faith can ignore any longer. And of course, this translates into a growing pressure from citizens, from associations, from NGOs that led governments to take very strong commitments. But the turning point comes when citizens realize that it is not enough. Realize that those commitments now need to be effectively implemented, and judges are perceived as legitimate actors to ensure this implementation and hopefully transform climate change law from a soft law with fuzzy political applications to a hard and binding law. And this shift is obviously tricky and open to criticism in Europe, and especially in France, especially for those who legitimately fear judicial activism. But I believe that those fears are mainly unfounded, at least when judges are called upon to hold governments accountable and draw the consequences of the strict and very precise commitments they made. As in my view, the courtroom can be and should be a place of political accountability. In any case, judges today find themselves at the forefront of the scene, and they also find themselves in a kind of competition. Because the questions raised are global and because the reference standards invoked are international or at least continental. In Europe, two quite different types of standards are invoked. On the one hand, the Paris Agreement, which is, as you know, non-binding, but precise, and which led European governments to take equally precise laws and regulations to implement their own commitments. On the other hand, the European Convention on Human Rights, which is a very general, a very plastic but binding text, and giving these differences, the ways in which judges draw climate consequences from these standards are naturally not the same. This leads me to my second question, which is why choose the Conseil d'État in this competition between judges? In my opinion, the Conseil d'État and the French administrative courts, which are specialized in reviewing administrative decisions made by the executive branch, have important assets to play a driving role in this jurisdictional dynamic. The first of these assets are, I shall say, time and money. The Conseil d'État is generally quick to issue its decisions. It takes on average 1 year to judge ordinary cases. And in addition, in cases where regulatory measures of national scope are challenged, it is the court of first and last resort. And this considerably shortens the time needed to obtain the final decision. The Grande Synthe case was thus directly reviewed by the Conseil d'État, as what was challenged was the refusal from the government itself to take additional measures in order to curb our greenhouse gas emissions curve. In addition, lawsuits before the French administrative courts are very inexpensive because it is not necessary to be represented by a lawyer, and because it is the judges themselves who conduct the investigations. Another asset is the ease with which it is possible to bring a case before the judge. The standing to sue is indeed assessed in a very flexible way. It is not necessary to be a direct victim or to have suffered damage to address the court. For example, in the Grande Synthe case, the mere fact that the city was exposed in some maybe 20 years to flood risks was sufficient to make its action admissible. In the case of the century brought to the Paris Administrative Tribunal, it was enough for the claimants to be environmental associations in order to have standing. And this generosity in admitting the standing to sue is a French originality which distinguishes it from many of its counterparts, especially in Europe. Another advantage is finally that the Conseil d'État has significant powers to enforce its sound decisions by way of injunctions and penalties. In a recent case involving air pollution, the Conseil d'État, for example, set a very heavy penalty to force the government to respect its commitments. And this was a strong signal and an essential prerequisite for the construction of an effective climate judicial review. So I come to my third question. What was effectively decided in the Grande Synthe case and the case of the century, and what questions remain at stake? I shall start by mentioning that those two cases followed different legal avenues. In the Grande Synthe case, the claimants chose the so-called legality litigation, which is a trademark of our administrative justice system and leads judges to only care about the objective conformity of an administrative decision with the law or superior norms. While in the case of the century, the claimants went through a more common compensation litigation, which led the judge to think in terms of harm and causality link. What matters here is that those two legal avenues trigger different relationships to time for judges. In compensation litigations, judges mainly look to the past as they are driven by the idea of redress. In legality litigation, they look to the past, but also to the future. This relationship to time is of some significance in climate matters, and we'll come to it later. This being said, the two decisions have much in common and share what makes them meaningful in the rising world of climate litigation. And in a very, I would say, interesting world, you described in your database the number of climate litigation cases. They are quite diverse, and of course, each case is interesting as such. So I will focus on the French cases. Thirdly, and this is fundamental, they both ruled that the national laws and regulations setting objectives for the government to reduce greenhouse gas emissions are legally binding and must be read in light of the Paris Agreement. And this represents quite a dramatic shift, as until now, such kind of objectives had always been considered merely programmatic and non-binding. How did the Conseil d'État, followed a few months later, but the Paris Administrative Tribunal, reach this conclusion? We essentially did so by comparing the very clear commitments made by France in the Paris Agreement with the will of the legislature, which in 2019 expressly stated that it wished, I quote, to secure the notion of carbon neutrality in order to concretely implement this agreement in domestic law. And I shall say that we felt encouraged to take the plunge given the climate emergency, as well as the place that national judges are by necessity led to occupy in the absence of global environmental justice. This position we took clearly distinguishes us from our Dutch or German counterparts that both issued breakthrough decisions, but grounded their reasoning on human rights standards. We felt in France that such a terrain is very slippery. To say that what level and what rate of reduction of greenhouse gas emissions the right to life or the right to a normal family life implies is not an easy task, especially since to date, the European Court of Human Rights has never answered such an abstract question. And so we tried our best to stick to precise legal provisions that we considered binding. Secondly, and this is equally fundamental, we decided not to wait 2030 or 2050 to verify if those binding objectives are met, but instead to control, as of today, that the government is following a credible trajectory to reach them. In doing so, the Conseil d'État projected itself into the long term of the fight against climate change. Despite the challenges inherent in such a control, which requires very technical assessment, and of course the capacity to reasonably predict that will happen in the future, I'm confident that we made the right choice for waiting until 2030 or 2050 would be tantamount to denying the urgency of acting today. Thirdly, both the Conseil d'État and the Paris Administrative Tribunal came to the conclusion that the government was not following a trajectory bold enough to meet its objectives. The Conseil d'État thus ordered him to take all necessary measures to correct this trajectory. And the Paris Administrative Tribunal, even though acting in a compensation litigation, considered that the best way to remedy the damages caused by the state's inaction was to order him to take similar measures. It is to be noted that both courts significantly did not specify the content of those measures, which are essentially political in nature. One could now ask, so what? Will judges be of any use with regard to climate change? This is a legitimate question to which I'd start answering by saying that no one will by itself solve the issue of climate change, neither governments nor associations, private companies or citizens. Nobody will reach any meaningful result in this matter if the others don't act as well. In this regard, I believe that we shall not expect too much from judges, but that is a very good thing that they finally take their share of the burden. This marks an undeniable deepening of the fight against climate change, which now concerns all powers, legislative, executive, and judicial. And I also believe that judicial decisions have the effect to greatly strengthen the pressure on the other branches of government and contribute to a stronger sense of urgency in society, all the more since more and more judges in more and more countries are on the way to get in line on what to expect from governments. But I reckon, and we certainly discuss about that climate litigation will test the limits of the judicial power's ability to compel the government to execute judicial decision. This is, in the short term, our greatest challenge, and we'll pay the greatest attention to how we can make the tools we have at our disposal work as effectively as possible. Thank you very much for your attention. I will now leave the floor to Justice Stéphane Hoynck, who actively contributed to the making the Conseil d'État's decision, and I will be very happy to later answer some of the questions you might want to ask us. Thank you very much again.
Thank you very much. It's a real pleasure to me to be part of this discussion organized with the Sabin Center for Climate Law. It is especially so because of the work done by the Sabin Center. The databases of past and ongoing cases that the center has developed and curated are wonderful tools for lawyers involved in climate change litigations. I am personally an enthusiastic user of these databases, and I know many judges, many scholars and petitioners around the world are also feeling the same. I think there would be room for academic research on how such powerful tools participate in the cross-fertilization of case law in many jurisdictions, how it inspires both petitioners and judges in climate change case law. This is not the topic of my intervention today, but I really want to thank you for bringing us this tool. Looking at the various cases regarding litigations against governments and their alleged inaction regarding and tackling climate change at the national level, it appears to me that petitioners enter in three various degrees in their claims and argumentations. I have identified three degrees in cases against states regarding domestic enforcement. These degrees are, so to say, piling up, and that's the first thing I would like to share with you today. The first degree is the claim that governments do not have an ambitious enough calendar for greenhouse gas reduction. And as you know, each state is bound by the Paris Agreement to present a nationally determined contribution, NDC, and a number of litigations worldwide claim that the national NDC is not ambitious enough, not far enough, not fast enough. The second degree involves another element of the Paris Agreement that I'm sure most of you know about, but it seems to me that it is not the case for the general public. I'm talking about the long-term strategies, or LTLEDs, that countries are invited to formulate to frame their efforts towards the long-term goal. The Grande Synthe case in France did not challenge the French NDC or its long-term strategy. It went one step further, claiming that however satisfactory the pledged levels of reduction were, however sound the long-term strategy might be, the government was not taking sufficient measures to actually be able to reach its targets. So this is a major dimension in this French case, requiring the government beyond pledges and strategies to actually deliver results. And I need here to make a point about those targets. The French case about climate change action revolves at this point, at this moment, not around the end goal of carbon neutrality, which is set for 2050, but around the intermediate goal for 2030, which is to decrease greenhouse gases emissions by 40% compared to the level of 1990. How hard is it to decrease emissions by 40%? When it comes to this, I like the image of a runner. Imagine you are running a marathon. You have an earpiece to communicate with your trainer. You've been running for a while. And at some point, your trainer tells you that he has a good and a bad news. The good news, he says, is that you are already halfway. You have run more than 20 kilometers, only 20 more to go. But he says, I also have some bad news. And the bad news is that if you want to finish the race with a decent performance, you will need to run the remaining 20 kilometers 3 times faster than what you have done for the first stretch. This is roughly the situation of France regarding greenhouse gas emissions. Compared to 1990, it has already cut its greenhouse gas emissions by 20%. Since it needs to cut them by 40%, it has done half the job. It has gotten halfway. But it has reached this effort in 30 years. And it needs to make a similar effort, an additional 20% decrease compared to the initial level by 2030. That is to say, it has to make the same effort it took 30 years to make in only 10 years. So the same effort must be done 3 times faster. And we can imagine also that most of the low-hanging fruits to reduce emissions have already been collected. So that's what's at stake. Is France on track to fulfill its 2030 targets? President Lasserre has mentioned it, stating that the 2030 objective is a mandatory duty for government, and accepting to control such an obligation that is essentially forward-looking are touchstones of the Grande Synthe case. So how do you control an obligation that is mainly looking at the future? The classical question for judges and for administrative judges in particular is to control an action or an inaction of the government that already occurred. The question being, why did this action not succeed? Is this lack of result the consequence of an illegal conduct? The question here is clearly different. What are the chances that the government plan will succeed? As you know, there has been 2 decisions in the Grande Synthe case. The first one was in November last year. The Conseil d'État believed then that the claim that the government was not on track to meet its 2030 target was a serious one. The reason for that is that the government is required by law to elaborate carbon budgets, showing the level of emissions targeted for each successive 3-year periods. So you have a number of steps showing a progressive decline of yearly greenhouse gases emissions. And the government did this carbon budget for the first time for the 2015 to 2018 period. And the government in this period of time missed its target by 60 megaton of carbon dioxide. That was a strong hint that the policies in place might not be robust enough to ensure a sufficient decrease of emissions for the future periods. And that's the reason why the Conseil d'État ordered the government to explain what were the tools it had put in place and those it intended to develop in order to meet its 2030 targets. So that was the first ruling. The second ruling in June this year was about examining the explanations given by the government. Here, I must insist on the line of reasoning we adopted. what we required from the government was a demonstration that it had a plan making it likely to achieve its 2030 targets. The point was not to show preferences for one line of action compared to another one. In the debates before us, there was some sort of consensus regarding the fact that there are three levers to reduce carbon emissions. One is shifting from fossil energy to carbon-free energy. The second one is energy efficiency, ensuring that a service is offered using less energy. And the third one is sobriety, the ability to produce and consume less. When it comes to the end goal of carbon neutrality in 2050, it is pretty obvious that there will be a need to use all these three levers on all economic sectors: transportations, building, industry, agriculture, power generation, etc. But regarding the intermediate 2030 target and objective of reduction, there is probably room for choices regarding which sector will contribute more to reductions, at what pace, and using this or that lever of action. The petitioners, in our case, expressed some preferences regarding the desirable mix of measures and try to demonstrate that the government was not engaged in that action, in that direction they deemed the right one. But we refused to enter in that discussion regarding which set of measures was the most preferable one. These are political questions, and the obligations to reduce emissions by 40% is not linked to a specific path. Therefore, judges must respect the fact that the government has a large margin of discretion regarding the tools it mobilizes to reach its goal. However, the government must present a persuasive roadmap of actual measures in order to convince the court that it will reach its emission targets. In this instance, the government did not present such a credible roadmap. That's what we judged in our case last June. On the contrary, it acknowledged that additional legal actions were required on its part to achieve its goal. That was precisely the line of reasoning submitted by the petitioners, and we confirmed the validity of this argumentation. Additional legal action was required, and the government's refusal to take this additional action was illegal. Therefore, we annulled this refusal to take additional measures, and we ordered the government to take some additional measures enabling the respect of the 2030 goal by March 2022. So this is a summary of what was at stake in the Grande Synthe case before the Conseil d'État. I might as well develop what was at stake in the Paris Administrative Tribunal case, but I guess I can stop for now and leave the floor open to questions and comments. Thank you.
Thank you very much, Chief Justice and Justice Hoynck. It was very interesting to hear you both explain what the rationale was behind the decision and how that plays into sort of the larger goals of the French government. And it would be interesting to hear a little bit more about the decision from the Paris Administrative Tribunal case as well, the case of the century, especially considering the decision earlier this month that ordering the government to actually repair the damages caused by the inaction to comply with the commitments that the government has made, and how that you talked a little bit about how the decisions relate to one another, but it'd be interesting to hear a little bit more about that if you can.
Yes, the case before the Paris Tribunal is labeled the case of the century, and I have to make two cautionary elements before commenting on that. The first element of caution is that this name, case of the century, is the name of the organization who decided to put a claim before the tribunal. So it's not necessarily the vision everyone might have about this case. The second cautionary aspect is that at the moment, we don't know if this case will be appealed by the government. So the case might end up at the Conseil d'État. So the remarks I will be making today are more on the technical side than on examining the merits of what was judged by the court. Maybe just to summarize what was at stake in the Paris tribunal case, one must remember that it all started with an oil tanker some 20 years ago that spilled oil on the seashore of Brittany in France. And some environmental organizations decided to bring the case to civil courts to have the company responsible for this oil spillage condemned for its action and for the damage to the environment. And the civil courts decided that when it comes to damage to the environment, and even in cases where there is no direct victim of the wrongdoing of a company, there is a possibility to have a claim based on the responsibility of the company. And what the company, if it is responsible for the damage, will have to do is not to pay a compensation to the plaintiffs, but it will have to repair in nature the damage it has done. And after this case law before the civil courts, Parliament decided to vote a law that was entered into our civil code, stating precisely that in environmental matters, it is possible to have an action that will lead to repairing the consequences of damages in nature. And so the originality of the case brought to the Paris Administrative Tribunal is that in this instance, it was not a company who was accused of wrongdoings in the environmental field. It was the government lacking action with regard to greenhouse gas emission reductions. So what the court decided was, I would say, as President Lasserre mentioned before, somehow backward looking at what the government has done so far and how and if this action was insufficient for the past. And the conclusion it reached was that compared with what I mentioned, the carbon budget for the first time period, the fact that it went beyond, it went above the limit of this carbon budget meant that the additional megatons of carbon dioxide that was emitted were considered to be the damage, the ecological damage that must be repaired. So the case brought to the tribunal led to this decision to make an injunction on the government to repair this effect, that is to correct the additional amount of carbon dioxide that is emitted to the atmosphere. So if we compare the two cases, and having this image of the oil tanker spilling the seashore, what the Paris tribunal case is about the effect of a spillage and saying that what has been done must be repaired. So the effect of past spillage must be corrected. The case before the Conseil d'État is different. Since we are looking forward, since we are looking at 2030 and beyond, we are trying to make sure that there will be no further spillage, that the situation in the coming years does not lead to this kind of effects. Of course, greenhouse gas is not the same thing as the spillage of oil, but as you all know, the more emissions there are, they just accumulate, and so the effects are more and more dramatic and cannot be compensated over time if they continue to go as they did before. So that's where these two cases complement, so to speak. One looking at correcting the past and one looking at preventing that in the future there is further damage to the environment by too much greenhouse gas emissions.
Thank you so much. This is very helpful. this is obviously a decision that both decisions that are applied within the French jurisdiction. But there's a question here, and you mentioned this a little bit in terms of the cross-fertilization and how it can impact other courts around the world. So the question specifically talks a little bit about human rights and the levels of greenhouse gas impact any other jurisdiction and the scientific consensus on that. So I was wondering if you can talk a little bit about that and the effect that the decision has had beyond France.
Well, maybe I would be able to say a few words about this question. We have no global justice, especially for environmental cases. So there is no global jurisprudence. But of course, in every judicial review we make at the domestic level, we take into account solutions made by others. And especially in the Grande Synthe case, there has been, of course, a thorough assessment of other judicial decisions made in Europe or elsewhere. And we are very keen on being sure that what we are doing is consistent with what others do. So no global jurisprudence which would be binding for us, but much care about adding our stone, I would say, to a consistent construction, and of course a keen attention to what other courts in the world do. There has been a question, and maybe I will be happy to answer it, about why the French Conseil d'État didn't ground its decision on the French constitution, as the German Constitutional Court did in a very famous decision made in March of the year. Well, of course, there are grounds in our constitution about environment, and in 2004, there has been an important vote which adopted what we call the Chart of Environment, which has been in fact integrated in our constitution, have the same status, the same binding effect at the core content of our constitution. And of course, you can invoke the violation of the Chart of the Environment as you can invoke the non-compliance with any other provision in our French constitution. What I must recall is that in France, there is a specialized court, the Constitutional Court, which can check that a law, a legislative initiative, is consistent with the Constitution. The French Conseil d'État can check that any administrative decision under its control respects the Constitution. And if the conformity of a law with the Constitution is challenged before us, we can send a preliminary referral to the Constitutional Court in order to check that this law is constitutional. There has been one decision made by the Constitutional Court in January 2020, which was about the conciliation between the right to a fair environment and the free enterprise principles. And the Constitutional Court made very clear that the right to a fair environment and the obligation for the government to protect environment had a constitutional status, what is called an objective, which has a constitutional value. But there has been no decision made until now, like in the German case you mentioned in our occasion, which quashed a law because it was viewed as insufficient to protect the environment. There has been no decision of that kind. And I think if such a decision was made in France, it would have been very contested or very discussed and debated, because what in fact the German Constitutional Court did in its decision was to say that the share of the burden between generations was too, I would say, was too burdensome, too heavy for future generations. It's more, I would say, an assessment of the desirability of a political objective compared with the consistency with a precise legal provision. So we chose a very different path, I would say, grounding our decision on the failure of the government to meet precise objective, precise commitments it took in under the Paris umbrella, and in fact integrated in our domestic legislation. That's I would say a more cautious approach. I don't say the other avenues are not possible, and of course we will expect a famous litigation brought to the European Court of Human Rights, the young Portuguese case, which will invite the European Court of Human Rights to to decide on these issues. But in France, we took a more, I would say, precise and more, I would say, specific avenue.
Thank you very much. I think there's another question here that relates a lot to what you were saying, and specifically to you, Chief Justice, that relates to how that experience could be sort of replicated in developing countries in the global South, in countries where there is no specific laws regulating climate change, but only the Constitution, and whether any type of commitments to reduce emission would potentially be balanced against the rights, the traditional rights included in their constitution. How could judges tackle that question in a similar climate case in that scenario?
Well, this is a difficult question because that's not the kind of issues that has been presented to us. And that's, I think, a very important point to make regarding case law and the various approaches that judges around the world have followed to answer cases in climate change litigations. We are very much dependent on the line of reasoning that petitioners bring to us. So we can only answer facing with a particular line of action. And I guess that's also the difficulty of these cases. We are facing a global problem, very obviously, and there is no global judge to ensure that each country does its fair share. So we have national judges, and they must act with the tools they have, with the norms they are entitled to control and to apply. And this obviously differs from one jurisdiction to another. That's there is the ground for, in terms of cross-fertilization, about seeing what imaginative solutions might be found in one jurisdiction and apply it somewhere else. But still, everybody works within a constitutional framework and a way of reasoning that is particular to its national jurisdiction.
Thank you. And there's another question a little bit more specifically about the Paris Tribunal case. If you can say a little bit more about this idea of treating the extra emissions as damage to the environment, if that was discussed in terms of additional consequences or in terms of direct harm to the climate system.
Well, the case is, in my recording, not very, doesn't go very far in explaining why it's decided this way. But what is striking to me is the fact that in various cases regarding the action of, or insufficient action of governments, we always have the same kind of question. And I might want to comment also regarding the Massachusetts versus EPA case of the Supreme Court, where the question was raised regarding Article 3 standing from the US Constitution perspective. With the question, you are very familiar with that, but with the question to know if the defendant has caused the plaintiff an imminent and concrete injury, and an injury that the court is capable of redressing. And that's more or less the same question the Paris court had to answer. Okay, any additional greenhouse gas emission is damageable to global warming. It's contributing to global warming, so it's something negative. But in the meantime, if you had one plaintiff coming to a court, a farmer, someone living on the coast side, and saying that this particular additional emission of carbon dioxide from France or from another country is responsible for the damage or the risk of damage to my property or to my way of living, that would be very difficult to ascertain, because it's not a specific carbon dioxide increase from one particular site or nation that is responsible for the damage. It's everything together. So I think that's the point, really, to focus on the fact that additional greenhouse gas emissions are damageable, and it is per se a damage to the environment that must be checked and must be corrected.
Thank you very much. I think just to finish us off, could you talk a little bit more about next steps in terms of, you mentioned that that there might be an appeal to the Paris Tribunal case, and in terms of implementing both decisions and enforcing what was said by the courts and was required by the court.
Yes, as President Lasserre mentioned before, the two cases more or less go in the same direction. They draw the same conclusion, that the government must act and have additional legal action in order to secure the curbing of greenhouse gas emissions. And in both cases, there were injunctions by the judge, by the Conseil d'État in one case and by the Paris Tribunal in the other case, for the government to take these actions. And as I mentioned it before in my presentation, what is really central and might seem frustrating for a number of activists is that we did not bring a particular pathway for government to act. And that's because we think there is a margin of discretion regarding the tools that might be used to perform this greenhouse gas emission requirements. So the next step, just talking about the Conseil d'État case, is March 2022. We require the government to have taken its additional legal actions by then. And then we'll see what happens. If we see a number of initiatives that have been brought into legal instruments, we will need to assess if they are satisfactory. If these tools are not brought, are not put into place, are not implemented, we will have the possibility to make further injunction, and what is more, to bring penalties to the government for its lack of action following the court order.
Thank you. All right, so I think that's all the questions that we had. Thank you very much for your time, Justice Hoynck and Chief Justice, for your availability and your openness to talking about the case. Is really interesting, and really interesting to hear how both cases are relate to one another as well, how they complement one another. And it was a pleasure to have you, and we hope to continue the conversation on this important these important developments in climate litigation.
Thank you very much. It was a pleasure for us too to share this this discussion, and thank you very much. And I hope we have the opportunity to discuss again about these important issues in the future. Thank you.
Thank you.